All rise. The Court of Appeals Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Deepwater versus Wells Fargo, our cause number CV130518. Let's begin with introduction of counsel. For the appellant.
Your Honor, Paul Girding Jr., Paul Girding Sr. For the appellant, and also with us today, former counsel for the Honorable Andrew Russell, who's now Commissioner in the Superior Court.
Very nice. Thank you for joining us. For the appellee.
Melissa Iyer, Julian, and Jay Curtis on behalf of the appellee Deepwater Divers.
Great. Thank you very much. Let me go through a few preliminaries today. Each side has 20 minutes. If the appellant would like to reserve time for rebuttal, when you go to the lectern, if you would let us know how much time you'd like to reserve for rebuttal, we will do our best not to poach on your beginning time so that you actually do end up with it. We are recording these proceedings today, both audio and video, and so when you go to the lectern, even though you've now introduced yourselves to us, if you wouldn't mind, please restate your name at the beginning of your remarks. We have reviewed the briefs. We have reviewed portions of the record that we thought were applicable to the arguments, so we're familiar with the issues and the arguments and the facts that are at issue on appeal, and you might wish to take that into account in your remarks today. So with those preliminaries out of the way, let's go ahead and begin with the opening argument.
Good morning, Your Honors. I'm Paul Girding Jr. for the appellant, Wells Fargo Insurance Services. Your Honor, to quote Judge Roden, where did that number come from, the verdict in this case? The verdict came from a case that never should have gone to trial in the first place. This case was ripe for summary judgment, and the court should have ruled in our favor after we moved for directed verdict and after we moved for judgment as a matter of law subsequent to the jury's verdict. The basis for why this case never should have gone for trial is simply there was never an appropriate meeting of the minds with regards to the essential terms of the contract. This contract to procure insurance with Wells Fargo Insurance Services acting as a broker for its insurers was an agreement to agree, and pursuant to the Arizona Supreme Court case law, every agreement to agree must maintain the essential terms of the underlying agreement. Pursuant to the case Gulf versus Grisham, an Arizona insurance contract requires that certain terms of the contract be included within every insurance contract. In this case, it was admitted by the appellee.
But as I understand it, the claim here was not a contract for insurance. It was a contract between the client and the agency to use its best efforts to obtain insurance quotes in a timely fashion. So what are the terms of that contract?
Well, we were sued not just for getting quotes, but they actually needed the insurance. They said that this was to procure them the opportunity to obtain an actual insurance agreement, which was required pursuant to their master services agreement. They said they made us aware of that master services agreement, which we were in part aware of, and that there were these certain insurance terms that had to be met. They asked us to procure bids on the potential agreement, but there was all of that was conditional upon our finding a carrier, conditional upon what the actual insurance was to be, conditional upon the coverage, what the premium would be.
Well, I think the question is there a distinction between a contract to procure insurance and a contract to procure insurance proposals?
Your Honor, we believe that this was a contract to procure insurance. That's what we were told, that they wanted an insurance agreement and that they had to have that insurance agreement in place by October 29 of 2009. That instruction was given to the appellant on October 26, a Friday, and that they wanted the insurance contract in place by noon of the following Monday. I appreciate the distinction between an opportunity to procure bids, but if we were just procuring bids, then there couldn't potentially be any damages here, because that would then rely upon the condition that there would be terms that were agreed upon with regards to the underlying insurance
Well,
contract.
But if, let's say that hypothetically, that this is a dispute over a contract to procure insurance proposals or bids, and that by a little bit before noon, or maybe in the morning of the 29th, Wells Fargo had said, okay, either, let's, first hypothetical, we have some proposals. And maybe they were acceptable, so Deepwater wires the money immediately and binds the deal. Or let's say that's one proposal, so that would not be, there'd be sufficient terms there. At least under the only case, your client would have performed. But let's say that you had Wells Fargo had gone back to them and said, we did our best. We were looking out there for those proposals, and no one, because of your track record, no one wants to do business with you. You've done your job. You were out there doing your job, and the fact that no carrier wants to do business, that's not your problem. So, I think the problem here, that at least I'm struggling, is what was this contract? We'll be asking opposing counsel this, I'm just certain of it, I just sense this is coming, about what were the terms of this contract? What was it?
Your Honor, if it was just an agreement to procure bids, then how could the appellant have been found liable for over $1 million of damages if it was based upon the conditions that there would be an appropriate carrier, that the premium would be appropriate?
Because they could have come in before noon and said, okay, here's the bucks, we've got it, bind it.
Again, Your Honor, too conditional. It's too conditional for those damages to actually accrue. For us to have a contract for insurance, for us to be held liable for not providing an actual contract of insurance, we agree that if the essential terms were there, if Mr. Gallucci said, yes, I'm going to provide you a contract, there's going to be a premium of X dollars, as we've seen in other cases, there's going to be this carrier, and I'm going to get you that certificate by Monday, then under ONA and the other cases which the court's well aware of, you could have a valid and enforceable contract and damages. Here, a conditional prospect of we might get you a bid, may or may not, if those bids were, let's say, yeah, you can have the insurance, but it's going to be $300,000 in premiums or $400,000 in premiums. And we know that the financial situation of the appellees was at issue here. So it's just too conditional for us to be held liable for something that subjective which was never met. When all of those terms of the contract were never agreed upon, the underlying essential insurance contract, how can we be liable for procuring bids without knowing who the carrier should be, what the premium should be, and even at the last minutes, the nature of the coverage itself was changing?
What contract do you think went to the jury, and what contract issue went to the jury, and what do you think the jury found?
The jury found that we breached a contract pursuant to the complaint to procure insurance. That's what the complaint said. That's what we were found liable for. And our argument is we can't be held liable for a failure to procure insurance where we haven't had an essential meeting of the minds with regards to the essential terms of the underlying insurance contract that was to be procured.
So if the other side argues that no, they weren't contracting for specific insurance, but only for the agency to present one or more proposals for coverage, then your position would be that they're changing the story.
Again, they are changing the story from the complaint, and again, we'd say pursuant to the case law that was cited with regards to the conditions and pursuant to the Felder case where we talked about contingent harm, understandably, Your Honor, and I know that you're well aware of what the Felder case said as you helped draft that opinion, that is just too conditional or too contingent of a reality for us to be held liable for $1 million in damages when, again, we don't know what the essential terms of the contract were or whether they'd ever be met. Your Honor, just as a warning, I'm going to seek 6 minutes for rebuttal time, which I failed to state. With regards to the negligent misrepresentation claim, paragraph 18 of the complaint stated that Wells Fargo Insurance Company had certain duties. Paragraph 19 of the complaint stated that there was a promise to procure insurance.
Why does this matter? When you went to trial, Deepwater made it very clear in the discussion on the jury instructions, if not before, that in their view, they had not pled, and in any event, they were not pursuing a negligent misrepresentation claim. So why does this matter?
Well, it matters, Your Honor, because under the law, under the McAllister case, under the Arnold case decided by Judge Silver, this is a negligent misrepresentation claim. You can cloak it as a negligence claim, but it is still a future promise. And a future promise is not a statement of fact that can be sued upon for tort recovery. So call it negligence or call it negligent misrepresentation. It is still a claim that has no legs to stand upon.
I'm having a hard time understanding the distinction here between just plain old simple professional malpractice or professional negligence by an insurance agent or agency and what happened here. I mean, if you persuade us that there's no contract, okay, and the complaint is, in my view, at best, and somewhat ambiguous, and in any event, there was 2.5 years of litigation that went after the complaint. Counsel says, we got a negligence claim here. And at trial, counsel for your client acknowledged that, yeah, there was a negligence claim there. No matter what, there was a negligence claim. Okay?
Yep. That counsel was me, Your Honor.
I know.
And I did it in all candor.
Yeah, and you were very professional.
We had just heard from the plaintiff's expert with regards to alleged duties that had been breached. Those breaches weren't pled in the complaint, but again, in all candor, I told the court we have an issue with regards to paragraph 19, which is this untenable claim for a future promise. Honestly, Your Honor, we also have this issue where there's now some professional negligence that has been alleged with regards to the duties and breaches testified to for the experts. That could have been handled by dropping the claim with regards to negligent misrepresentation, withdrawing that from the jury, or giving the jury the appropriate jury instructions which we submitted, or the court could have amended the pleadings appropriately for the jury prior to their making the decision. Instead, they took the whole package, the improper negligent misrepresentation argument, which was the thrust of their entire case, and lumped that in with the negligence claim. I understand, Judge, where there's a tenable argument with regards to a potential legal claim and a jury makes a decision, that verdict should stand. But here we're saying it's so colored by the alleged promise, that the tort theory being you breached a promise to give us insurance. And the law says there's no such claim in Arizona. With regards to the MSA disclosure, 12 days prior to trial, as indicated the briefing, we were handed a master services agreement. This came after we first requested that in a request to produce from the plaintiffs. We were told they didn't have it. We were only given 3 pages, which included language with regards to potential defaults if insurance was not kept in place. Nothing further. We also issued letters of rogatory out of state to the other party to the contract requesting their entire file, all correspondence. We got nothing. We got nothing from the plaintiff, and we got nothing from Badger Oil. We then moved in limine appropriately with regards to our limiting their ability to use the contract, as there was no contract at issue to support their damages, that being the master services agreement. Although they then switched their determination and said, no, there's a separate purchase order that's a contract. The judge clearly didn't like that in early January and indicated to them he was troubled with why don't we have the contract. Just a few days later, and just 12 days prior to trial, we were handled the full master services agreement, which came from Mr. Curtis, who contacted Badger Oil and said, essentially, we need that, let's get it. Suddenly it appeared with correspondence dating back to 2007. We moved for a continuance for the opportunity to depose Badger Oil with regards to the contract, essentially to the termination provisions that had not been provided in the previous drafts, which included the right of Badger Oil to terminate the agreement, 10-day rights to cure. Essentially, we lost the opportunity to argue to the jury or subpoena Badger Oil to come in and testify with regards to whether they actually had a right to the contract given the ongoing breach and their failure to maintain insurance.
To maintain insurance.
They breached the contract, they being Deepwater, in September of 2000. 7 for failure to keep the insurance in place.
The record reflects that Wells Fargo knew that there had been a failure to pay for the umbrella, the $7,500.
Absolutely.
And although I guess, as I understand, the carrier had not formally terminated the insurance contract for non-payment, they knew about the breach. And they also had Exhibit 91, which were the requirements under the MSA, Badger's requirements for insurance. So what more did they need? Why is this a material problem? Even if granting you everything that happened, and there was late disclosure. So what? Why is that material? When your client knew about the breach, it had all the information it needed. Well, what more did you need?
Well, we wanted the opportunity to actually depose Badger Oil and vet the issues and with these witnesses with regards to what would you have done with relative to the termination clauses that were within the contract. Would you have even entertained this bid if you had known that there was a breach? All we knew from the previously disclosed information was that there would be a default. We never knew the consequences of the breach, and we never got the opportunity to vet the consequences of the breach with that third-party Badger Oil, and that's because that was only given to us 12 days before trial. Your Honor, I'm going to reserve another 5 minutes for rebuttal.
Thank you.
Thank you.
Good morning, Your Honor. My name is Melissa Iyer-Julian, and I represent the Appali Deepwater Divers Incorporated. I'll begin by pointing out that this case and the several issues raised on appeal are not the result of trial court error, but failed litigation strategy. Waiting until the eve of trial to raise a discovery dispute or to submit special interrogatory jury instructions, or taking an all-or-nothing approach to attacking only liability and not submitting or presenting any rebuttal evidence on the issue of damages. And it is not the function of this court to help Wells Fargo correct strategic mistakes, but to preserve and identify actual trial court error that resulted in prejudicing the outcome of the case. Now, to first address the distinction discussed during the appellant's argument regarding the contract to procure insurance versus a contract of insurance. As this court has long recognized since Oney versus Barnes, again in Premium Cigars, and then again in Webb versus Gitlin, there is a clear distinction between a contract to procure insurance and a contract of insurance. And if you think about it, to hold otherwise would essentially eliminate any obligation on the part of the broker to perform and carry out its duties in a competent manner. Because essentially what the appellant is arguing is that the contract to procure insurance and performance by procuring the actual policy of insurance happen at the same time, so that there can never be a breach by the broker of the failure to procure insurance, because they have no contract obligation until the insurance is in place and their obligations have already been satisfied.
That case law that you mentioned came many, many years before the Supreme Court's discussion of the differences between contract and insurance, beginning, if not with Barmat, but shortly before.
Between contract and tort.
I'm sorry, did I say, forgive me, contract insurance, thank you, between contract and a negligence claim.
That's true. And in Barmat, the Supreme Court did identify that there are many duties that arise and are implied as a matter of law from the services a professional like a lawyer or an insurance broker provides. And that's consistent with the court's decisions in Oney and Premium Cigars, even though they came before. However, what the court in Barmat created a special exception to that general rule, which is there can be, in addition to the implied legal duties that give rise to tort liability, there can be contractual liability when the professional undertakes a specific contractual arrangement. And that was reinforced by the court's later opinion, this court's later opinion in Asphalt Engineers versus Galusha.
So what was the specific contractual undertaking that Wells Fargo allegedly undertook here?
The specific contractual obligation was as testified to by Mike Fennessy and not contradicted by Mr. Gallucci in the record, which we've cited to at page 30 of our answer brief. Mr. Fennessy testified that on Friday, October 26th, he called Mr. Gallucci and said, I need you to procure insurance proposals with these specific requirements by noon on Monday, October 29th. Do you accept that contract obligation? And Mr. Gallucci agreed.
So it's the noon deadline that makes this fall within premium cigar?
That makes it a specific contractual obligation, yes.
So if we remove it, if in fact the facts were different and your client had not requested a noon deadline, but everything else was the same, then would it be barred under premium cigar? The it being a contract claim.
Well, I think it would depend on whether or not there were any specific contractual obligations, and I would point in that regard to the facts of Asphalt Engineers to draw the distinction. In that case, the court pointed out, Asphalt versus Galusha, that an attorney, when an attorney undertakes a general obligation to represent a client, those implied legal duties apply, but not necessarily arising out of a contract. However, in that case where the attorney agreed to record 2 specific liens and failed to do so, it gave rise to both contractual liability as well as tort liability.
So this is an important point, I think, or at least it strikes me as such, that the specific undertaking that goes beyond the general duties implied by law on the insurance agent here was the commitment, the alleged commitment, to procure solicitations or bids or insurance on or before noon on Monday, October the 29th.
Yes, and you'll see from the record that that contractual obligation is also supported by the fact that this wasn't just a generic request, we need insurance by this date. Mr. Gallucci was informed as to why they needed insurance by that date. He knew that they had a very significant job with the most significant client they had beginning on Monday, October 29th. He knew that was why they needed the insurance in place, and he promised to have the bids to them by that date. And the parties continued to act as if they had that contractual obligation.
How is that different than the professional insurance company's undertaking, which is a professional negligence issue, not a contract issue? I mean, your client says, I need this by Monday. The insurance company says, okay. They undertook to do it. Well, how's that a contract? It seems to me that within the analysis of RMAT and perhaps even premium cigars, that's a tort, not a contract.
Well, I think it depends upon whether or not the parties had a meeting of the minds and what their reasonable expectations were. In this sense, rather than going to an insurance agent and saying, I'm in the business of deep water diving, I need generally for you to procure an insurance policy to support my business as a going concern. This, by contrast, was a specific policy needed for a specific job, and Mr. Gallucci was informed that the date for which the job was going to begin, the terms of insurance needed for that specific job, and the consequences. He knew that this was a $300,000 job for deep water divers. That's in the record, an email from Mike Fennessy to Greg Gallucci saying we have $300K on the line.
What about the two missing issues of no idea discussion of who the carrier would be, and second, no idea discussion of the premium for the policy or the policies?
Well, and again, the parties did discuss the terms that were required based upon the MSA. That's in Exhibit 91.
Exhibit 91, I understand, but what about lack of the carrier and the issue of the premium?
Again, the obligation, the contractual obligation on the part of the broker is not unlike a real estate broker. His obligation was to produce a ready, willing, and able insurer who could provide coverage. Now, the failure to produce a ready, willing, and able insurer is the breach.
But what if there's no one out there who wanted, as it turned out, Mr. I believe it's Haynes on behalf of Trident or the wholesale broker, they didn't want to insure this company. They didn't want to insure your client.
Well, that's based upon a single carrier. However, Mr. Gallucci is the professional holding himself out as a commercial lines specialist in this area. It was his obligation not to undertake that contractual responsibility of providing the bid proposals by noon on Monday if he didn't believe. He was fully aware of Deepwater's track record. Wells Fargo had been its agent for the duration of its business. So it's his choice at that point whether or not to undertake that obligation, to accept Mike Fennessy's offer.
So
Can you
if he
provide
had
the
gone out
insurance?
and performed and couldn't come up with anyone who wanted to do business with your client because of your client's track record, he'd be in breach? Is that what you're saying?
Yes, based upon his promise, his contractual agreement to provide those bid proposals by noon on Monday.
So if no one wanted to bid, he's stuck. He breached the contract?
He breached the contract by failing to provide bid proposals, yes, because he promised that he would have those in place by Monday. If he didn't make that promise, he wouldn't have that obligation.
I'm sorry, I don't mean to beat a dead horse here, but this is the problem I'm having. What is this contract? Is this a contract to procure insurance, or is this a contract to procure some bids or proposals? Because if it's a contract to procure insurance, and no one is interested in doing business, I'm having a hard time seeing how the Wells Fargo can be liable, assuming that they act in good faith and do their best to obtain. Because your client testified he knew, Mr. Fennessy knew that Wells Fargo was not an insurance carrier, and they were not going to be writing the risk.
And in response to that, I'll point to the language in both the Oni case and the Premium Cigars case. Oni states, and I quote, "Liability of the broker in such cases must be predicated on his failure to procure insurance as agreed, rather than on an alleged contract of insurance made by him. It is, as you stated first, the failure to procure the bid proposals. The bid proposals is what he promised to produce by noon on Monday, October 29th. And it is that failure to procure those bid proposals, to produce a ready, willing, and able insurance provider that constituted a breach of the contract to procure and cause damage. And that is supported by the evidence in the record.
So just to make sure I'm also following, you're saying that if a hopeful insured calls an insurance agency or insurance broker and says, I need coverage by tomorrow, by next Monday, by next week, whatever, and the insurance company says, okay, and then they can't find any. Let's assume they use reasonable efforts. If they can't find any, then they're simply on the hook for the failure to whatever damage is caused by that absence of coverage.
It would depend upon their acceptance of the offer made by the client. If they say, well, you need coverage by Monday, I'm sorry, but I'm not sure, I'll do my best, then they wouldn't be under any contractual obligation to procure insurance bids by a date certain. But if in the alternative they say, absolutely, we will have that bid to you by noon on Monday, then yes, they are contractually obligated to produce that bid proposal.
And if they surveyed and queried 100 underwriters and 100 different carriers and they all said no, then they just buy the risk under this analysis.
They do if they promise to produce a policy by a date certain. It is their responsibility to either accept, just as with any contract. We as the offeree always have the option of either accepting the undertaking or rejecting it. And then there's no contract form. But when the broker accepts the offer and undertakes that specific contractual obligation, they have a duty to produce a bid proposal by the date they promised to do so. That is where the contract arises.
And if they can't, then it's just their tough luck.
If they've promised and they can't, then yes, they've breached their obligation, the obligation that the parties had a meeting of the minds on.
I mean, wouldn't this precedent, if it became one, require that insurance agencies such as Wells Fargo Insurance Services and a myriad of others would always have to simply say, well, we'll do the best we can, which is sort of assumed anyway, but they'd have to send an immediate email of disclosure confirming that nothing's promised.
Well, yes. I think when an insurance broker makes an affirmative promise and in exchange gets the promise of, in this case, a significant commission on what is going to be a very large premium, when they make a specific promise and they know it's for a specific job, if they don't come through, they should be contractually liable. If they have any question in their mind, as the professional in the industry, as to whether or not they can procure that policy, they are free at that point to reject the offer, to say, I can't promise contractually to you that I will have that bid to you. And that is within the ability of the offeree in any contract to reject an offer, and no contract would be formed. But when there is a meeting of the minds as to those basic terms under ONI and premium cigars, a contract to procure insurance proposals has been formed. And for that reason, the trial court properly denied the judgment as a matter of law on the issue of whether or not a contract was formed. There was ample evidence to support the meeting of the minds on the material terms. The promise that we discussed to have insurance proposals, and I'll clarify that, not to have insurance coverage.
Right.
He promised to have proposals to them. But there is also sufficient evidence in the record, viewing the record in the light most favorable to upholding the contract verdict, that there was evidence in the record that our clients were ready to pay any premium they were presented with, that they had investors and money, and the emails in the record were replete with requests. Please send us the wiring instructions so that we can wire the premium right away.
I know you want to move on, and probably so do we, because we're short on time. But let me make sure I understand. It is your position that the specific promise here, we'll get this to you by Monday, we'll get this done for you by Monday, that specific promise takes this out of the realm of the discussion by Justice Feldman and Barmat about when is there a contract and when is there a tort. And this is like the agreement of the lawyer to file two liens. That's what you're saying.
Exactly. And I'm not saying that in every single scenario when a party goes to an insurance broker to seek insurance that they're going to give rise to a contractual obligation, just that in this scenario it did.
Right. If it's just a matter of getting bids and proposals, that normally wouldn't be a contract.
It normally wouldn't, in the absence of a specific agreement like there was here.
If they didn't use reasonable efforts, there might be professional negligence.
Exactly. Which is why the court was properly, the issue was properly submitted to the jury, because there is a basis for a contract, and the facts and the evidence supported the testimony of Mike Fennessy, the failure by Gallucci to contradict. If you look at our answer brief at page 30, Mr. Gallucci himself agreed in his testimony that a contract was formed. He agreed that Wells Fargo accepted an offer. That's a verbatim testimony from Mr. Gallucci, that Wells Fargo accepted the offer to procure insurance, that there was consideration in the form of a commission to be paid, and that is the formation fundamentally of a contract.
You know, with the limited time, if I might suggest or invite you to address how the evidence supports this damage verdict.
Yes, thank you, Your Honor. That's exactly what I hope to address during my time. Importantly, I'd like to point out that the issue regarding lost future profits was only raised by way of a motion for new trial. It was not raised in the defendant's motion for judgment as a matter of law. That seriously impacts the standard of review, because we're looking at it from the perspective of whether or not there was an abuse of discretion in the denial of the motion for new trial on the issue of lost profits. Now, the standard for determining the appropriateness of the award of lost profits is twofold: the fact of damage and whether the jury was provided with a method of calculating that damage with reasonable certainty. Now, Wells Fargo doesn't challenge the fact of damage. They concede in their opening brief that we had evidence sufficient to demonstrate the fact of damage up to $521,000. So they're only challenging the method of calculating damages beyond that amount, and that is the only issue to be looked at on appeal. And the evidence supporting the method of calculation is set forth in the testimony of Tom Fennessy and in the documentary evidence in Exhibit 180, setting forth Deepwater's financial statements. Tom Fennessy was Deepwater's CFO. He had a master's and bachelor's degree in international finance and business, and he started his own independent diving company after Deepwater failed. He had significant industry experience. He testified that he did a specific study of Deepwater divers' competitors' profit margins from 2006 to 2010, and he confirmed that his valuation was based upon his knowledge of those facts. He explained that the valuation of smaller diving companies during that time frame was based upon the number of master services agreements they had in place and the value of those master services based upon the customer's capital expenditure budgets that he personally
I will tell
reviewed.
you on that point, I found that a little suspect, just because, as I understand the master services agreement, it essentially puts a company in, it makes them a qualified bidder, but there are no guarantees whatsoever that the company is going to get any subsequent contracts.
That's true, Your Honor, but as the court pointed out in Felder versus Physiotherapy, the guarantee isn't the measure for determining whether a jury may award lost future profits. In Felder, he was a minor league baseball player. He hadn't yet been called up to the major leagues, but the court affirmed an award of lost future earning capacity to him because the prospect that he had demonstrated ability to succeed and intent to do so in that field was not too speculative. Deepwater had been called up to the majors. It got the $300,000 award of that Badger Oil contract, and to expect that it would have continued to get those lucrative contracts, even 10 more of those contracts would yield $3 million in revenue, was not too speculative to support the jury's verdict. As the trial court found, it was within the range of evidence supported by Tom's testimony, and it should be affirmed on appeal.
Thank you.
Mr. Girding, may I ask you a question to start the rebuttal?
Certainly.
Say no, just say no.
I will never say no to this court.
If we were to agree with you there was no contract, does that help you very much? Because the jury found against your client on negligence as well.
Well, again, Your Honor, we believe that that was improperly presented to the jury with the negligent misrepresentation claim and the future promise, and it was so inherent to the total picture that you can't pull the two apart. And negligence, there was no other breach that was alleged other than this future promise. That was the only thing that was actually in the allegation of pleadings, and the reason that I stated that negligence was at issue, although it had not been pled, was because we had just heard moments before the testimony of an expert that said that there may have been another failure on the part of Mr. Gallucci with regards to
What
insurance.
about the effect, or at least the notice provided by I think it's the second amended or supplemental joint pretrial statement, in which the issues that the parties dispute are set out in terms of, in part, contract, and in part, what I will just call common law professional negligence. And I don't see anything in there that talks about a negligent misrepresentation claim.
Well, it was part of the overall briefing time and again that we were seeking via motions in limine and via the motion for summary judgment. We want this negligent misrepresentation claim to be called out for what it is. We want jury instructions on that issue.
See, what I see is that your client really wanted this to be a negligent misrepresentation claim for obvious reasons. And the other side said, no, that's not our claim. Our claim is just plain old negligence as an alternative claim.
Your Honor, in all candor, I am aware of no case law that says that a statement of a future promise, which cannot be a statement of fact, is anything but negligent misrepresentation, and it should not be allowed under Arizona law, pursuant to the cases that we cited.
Well, what's the difference then between that point that you're just making and the failure of, or the alleged failure of an insurance agent to procure insurance proposals at the request of a client.
It's, again, the conditional issue of requesting insurance proposals is different than what we repeatedly heard from the other side. Repeatedly we heard, if you read ONA the way we read it, there simply can never be a way to sue an insurance broker for breach of contract. And we said that's not true. If you have the essential terms of the agreement, the contract premium, the carrier, and what's generally the nature of the coverage, you've got enough pursuant to the case law to bind the broker. But when you have I want to get some bids, and by the way, I don't have anything, I only have $18,000 is what Mr. Fennessy said. So that bid had to come in there. It's just too conditional for us to be held liable for the total amount due. That's why we tried to carve it out. That's why it should have been pled separately as negligent misrepresentation and negligence, and the jury should have been allowed to consider it separately, and frankly, the negligent misrepresentation claim should have been stricken because it was based upon a future promise. With regards to ONA, Your Honors are correct. ONA was decided in favor of the broker. In that case, there was a proviso that was inherent to the contract that a qualified insurance company would be found. So even though they didn't actually agree to that, the Court of Appeals said in that case, it was understood by the trial court that there was an understanding, and here it was certainly understood by Mr. Fennessy, that the ones that carried the heat, to use his own words, were the insurance company. If no one who carried the heat stepped up to the plate, we simply couldn't be held liable for breach of contract because we're not the ones who are determining whether or not a carrier is going to step up and handle the insurance. That proviso was inherent to the contract in ONA and should be inherent as reflected by Mr. Fennessy's testimony, that he understood that a carrier had to come in and step up and take on the responsibility of providing coverage. With regards to damages, we'll be brief. Under Felder, you've got to have some reasonable certainty, and Judge Gummel's aware that that includes certain criteria or mathematical calculations that are reliable in this type of contract case to provide damages. In that reliance, you should have accounting, you should have tax records, or you should have previous transactions. In this case, what Mr. Tom Fennessy did was he took capital expenditures of diving costs of customers that were wholly unrelated. And by the way, the survey of other customers was stricken from the record, and the jury was instructed not to consider that. And I believe that was at page 160 of the transcript on February 1, 2011. The $680,000 figure that he struck upon was because of the capital expenditures of other parties with regards to total diving expenses. This company had a history of only $53,000 of profits, $190,000 of contracts total, divided by 2, that's $90,000 per contract. So instead of going to the actual company at issue and the transactions at issue, Mr. Fennessy ignored the $90,000 figure, and instead, in presenting goodwill evidence, he went to a $680,000 figure, looking at outside information that was totally irrelevant to the calculation. For that reason, Your Honor, we believe that this testimony, which was never presented as lost profit testimony, which was solely presented within a conversation with regards to goodwill, should not be considered a basis for lost profits. It was never pled, it was never argued, and if it was, they would have pointed to that instead of trying to create an issue with regards to goodwill, which is a tacit admission. That lost profit argument was never made. Thank you, Your Honor.
Thank you both for your argument today. We appreciate it very much, as well as your briefing. We're going to take this matter under advisement. We're going to adjourn briefly so the bailiff can set up the courtroom for the next argument. And then I have a couple additional instructions for the bailiff I'll leave on the desk. Thank you very much.
Thank you, Your Honor.